Excellent. Okay. People are trickling in. We'll give it a minute or two and then we'll start introductions. Thank you, everyone. Right, people are still trickling in. We're going to give it one more minute and then we'll get started on today's webinar. Thank you so much, everyone, for joining. All right, I'm gonna go ahead and get started because my part is very small and I want to give as much time to our guest, Stefan Cassella, this morning or this early afternoon. Hello, everyone. My name is Asha Brundage Moore, and I am the director of the Collaborative Clinic for Nonprofit Viability here at the Yale Center for Environmental Justice. The center is a joint initiative of the Yale School of Law, Yale School of the Environment, and Yale Center for the Study of Race, Integrity, and Transnational Migration. Today's webinar is the first in a series of webinars relating to topics on nonprofits, organizational, and transactional law. And we are thrilled to be joined by our guest, Stefan Cassella, who will share his experience in this area. The question of asset forfeiture is not typically a conversation in environmental spaces. But has become more relevant in this year, and a lot of things that the government is doing differently in the way that it interacts with civic society and environmental organizations. This is not only true in the United States, but in government overreach around asset forfeiture has become a topic internationally. And the center, as well as the Collaborative Clinic for Nonprofit Viability, is looking forward to engaging with international audience on this topic in the new year as well. A little bit of housekeeping. Please feel free to introduce yourselves in the chat. And if you have any questions that arise during the webinar, put them in the Q&A box, which I will monitor and raise to our host or our moderator and our speaker as they come up. With that, I'm going to turn it over to Professor Gerald Torres, who is the faculty director of the Yale Center for Environmental Justice, who will introduce our speaker. Thank you so much, and looking forward to a great webinar.
Thank you, Asha. It's my distinct pleasure to introduce Stephen Cassella, who formerly at the Department of Justice in the Asset Forfeiture Division, or section, I should say. And he is probably the leading expert of the law in this field. And he's going to walk us through the way it works both at the federal level, the way it works at the state level, the civil, and I think there'll be some criminal forfeiture discussion as well. I will interject on occasion, although I'll mainly try to stay out of the way. And with that, I introduce to you and turn it over to Steph.
Well, thank you very much, Professor Torres, and thank you all for your interest in this topic. I'm pleased to join you this morning, and I hope that we have a good discussion. I am a former federal prosecutor. I was in the Department of Justice for 30 years, and now I'm working as a consultant both to defense firms and to law enforcement, and also serving occasionally as an expert witness and a lecturer. So the idea this morning is to provide you with an overview of asset forfeiture and how it works, with an emphasis on how it applies in environmental crimes. So in particular, I want to talk about the government's abortive attempt to use civil forfeiture to claw back money from environmental groups in the Climate United case, and talk a little bit about how that litigation then has moved off in another direction since that time. But first, we have to talk about the basics. So I'll begin with what asset forfeiture is and what purpose it's intended to serve. Talk a little bit about what can be forfeited in connection with an environmental crime, and then I'll summarize the procedures. I'll talk about criminal, civil, and administrative forfeiture and what the government has to show to begin the forfeiture process in all of those cases. And I'll talk about the due process rights of property owners whose property is seized in a forfeiture case. And at that point, after discussing the why and the what and the how of asset forfeiture, we'll get into the Climate United case and what happened there. Our format is for me to speak for roughly 45 minutes and saving time at the end for additional questions. But as Professor Torres mentioned, along the way, I've invited him to interject with questions that he may have or that any of you have forwarded through the chat box, and feeling free to stop me and say, can you please clarify that, or can you speak a little bit more about this or that or the other thing? So let's get started. Hold on, I got to advance my slides. Yeah, so those are the topics I want to talk about. What is forfeiture? What's the law enforcement purpose? What can be forfeited, and then the procedure, and then we'll get into the Climate United case. So, what's asset forfeiture? It's a law enforcement tool. It's the confiscation of private property by the government upon a showing that the property is either illegal to possess, or because it's contraband, or it's connected to a crime in some way. It's connected in some fashion to a criminal offense. It's a law enforcement tool that's intended or that's invoked to serve some either remedial or punitive purpose. And generally, it's intended to serve both of those purposes. For example, the government may want to recover the proceeds of a crime to punish the wrongdoer, because leaving a wrongdoer in possession of the proceeds of his crime is the opposite of punishment, and to deter other people from committing the same crime. Letting criminals keep the proceeds of their crime will only incentivize others to do the same thing. But beyond that, it's also intended to recover property for victims. The government's ability to recover property from the wrongdoer far exceeds the ability of the victims individually to do that. And the first priority of the government when it recovers property in a case where there are victims is to use it for reimbursement of the victims and their losses. In the last 25 years, for example, the government has recovered and returned to victims $12 billion through forfeiture cases. So that's when we talk about recovering the proceeds of crime. When authorized by statute, the government also is able to recover the instrumentalities or the property used to commit a crime. You know, an airplane used to smuggle drugs, or a gun used to rob a bank, or a business used to launder money. Those things also achieve both punitive and deterrent purposes, but they also prevent the property from being used again. They would disable organizations from using their economic influence to commit crimes in the future. So we would call this in criminal justice parlance part of incapacitation. But beyond that, forfeiture also serves a public policy and public safety purpose. It can be used to protect the financial system from being used by international criminals to evade sanctions. It can be used to prevent foreign corrupt officials from investing their money in the United States, from skewing markets by buying up all the real estate and changing the price structure such that others cannot afford to participate in the market. And it can be used to level the playing field so that people who have honestly derived funds are not competing economically with those who have tax-free criminal proceeds. So those are all the reasons why the government does asset forfeiture. Now the question is, what can the government forfeit through asset forfeiture? Well, for many crimes, Congress has authorized the recovery of both proceeds and the facilitating property. But some statutes are not so broad. And you have to look at each statute and see what Congress decided to authorize. As it happens, in cases involving environmental crimes, the government is limited by statute to recovering the proceeds. That is, it can seek the forfeiture of the crimes that are listed in a list of statutes that Congress has put into the forfeiture law, and you see them there on the slide. Those are not all environmental crimes by any means, but those are the ones that Congress thought important enough to include in the forfeiture statute and to authorize the forfeiture of their proceeds. Now, it's not obvious what the proceeds are of some of those crimes. I mean, generally, the only thing that someone gains by violating something like the Safe Water Drinking Act is the money that he saves by not complying with the act. And that amount of money would be forfeitable. But as a practical matter, in environmental cases, if the government is seeking to recover something, it's probably going to rely not on the environmental statutes themselves, but on other federal laws, such as mail fraud, wire fraud, honest services fraud, bribery, or theft from a government program. And as we'll see, that's what the government initially tried to do in the Climate United case. But we'll come back to that in a few minutes. So first, we want to talk about forfeiture procedure and due process, and how the government does it. So what is the process? So the procedure can be criminal, as when the forfeiture is made part of the defendant's sentence after he's convicted of a crime, or it can be civil, as when the government brings an in rem action against property, and in conjunction with or separate from entirely a related criminal investigation. It can also happen by default. That's when the property is seized by a law enforcement agent for intending either civil or criminal forfeiture, but no one files a claim. No one contests the forfeiture. And in that case, the forfeiture is entirely handled by the seizing agency, the FBI, the IRS, the DEA, whoever, and the property is forfeited by default if after notice was given, no one files a claim. So you have criminal forfeiture, civil forfeiture, and what that last one, that default proceeding, is called an administrative forfeiture. Here's the key point. In all of those instances, whether the forfeiture is part of a criminal sentence, is subject to a civil in rem proceeding, or is forfeited administratively. In all of those instances, unless the property is contraband that's simply illegal to possess, there has to be some nexus between the property and a crime. No connection between property and no crime, no connection between property and a crime, no forfeiture, not criminally, not civilly, not administratively. So what the nexus has to be varies from crime to crime. What can be forfeited in a fraud case may differ from what can be forfeited in a drug case or a money laundering case or a terrorism case. You have to look at the statute to see what Congress authorized in each instance. I've already told you that in an environmental crime situation, it's probably only going to be the proceeds of the crime that the government can recover. But there has to be some connection to a crime. I don't want to get into the details of the differences between criminal and administrative forfeiture or criminal and civil forfeiture, for example. Each has its advantages and limitations from the government's perspective. but just let me give you a 30,000-foot overview. In short, in a criminal case, there must be a criminal conviction, and the government then can only forfeit the property connected to the crime for which the defendant is convicted. If the defendant is charged in a 3-count indictment, but he's only convicted of count 1, then the government can only recover the property involved in count 1, not count 2, not count 3. Why is that? Because forfeiture in a criminal case is part of the punishment imposed on the defendant for the offense for which he's convicted, which means that the forfeiture has to be limited to the property derived from the particular crime with which the defendant was charged and with which he was found guilty. Now, civil forfeiture is broader in some ways. As long as the government can prove that a crime was committed and that the property was connected to that crime, it can forfeit the property. It does not have to obtain a criminal conviction. It's not limited to a specific offense. Why? Because in a civil case, the forfeiture is in rem, not in personam, in rem, which means that the focus is on the property, not on the property owner. So if the defendant is a drug dealer or a child pornographer, it's enough to show that the money was derived from that activity without having to link it to a particular drug deal or the particular sale of illicit images over the internet. And there's no requirement of a conviction because the government doesn't even have to know who the bad guy was. All it has to do is show that the property is that a crime occurred and that the property is derived from a crime. That's why civil forfeiture is so important, for example, in cases involving recovering the proceeds of crypto fraud schemes. The victim knows he's been defrauded. And through the blockchain analysis, we can find the property, but nobody knows who the guy was who stole the money from him. He may be some person in South Korea or North Korea or China or Asia, somewhere else in Asia or in Africa. But if the Bitcoin or Tether or whatever it is can be traced, then the property can be forfeited in the civil in rem setting. But here's the important point. The government still has to prove that there was a crime and that the property was connected to the crime. It doesn't have to be able to identify who the bad guy was or obtain a criminal conviction, but it does have to, just as in a criminal case, establish the 2 important points. Crime occurred and the property was derived from it. Let me take a breath there before I talk about the actual seizure provision and see if Professor Torres or anyone has a question.
No, I think it's clear, but I think it's important, and I'm glad you made the point that this distinction between civil and criminal forfeiture and the lower level of proof that is incumbent upon the government to make in each of those settings or in the civil setting. And it's important, I think, for people not to get those confused. So,
yeah, that's worth just clarifying. Obviously, in a criminal case, you have to prove the defendant's guilt beyond a reasonable doubt. But once you've done that, you only have to prove the nexus between his crime and the property by a preponderance. In the civil case, you have to prove 2 things, the crime and the connection, but both can be established by a preponderance. And the rationale for that as a matter of constitutional law is in the latter situation, you're only taking property, you're not depriving someone of his liberty. And it's the beyond a reasonable doubt standard only applies when liberty is at stake and not when property is at stake. That's why in all cases involving lawsuits over money, the standard is preponderance, and that's why it's preponderance in a civil forfeiture case.
Thanks. I think that's really important for people to keep that distinction in mind.
Okay, so with that brief introduction, we've talked about what forfeiture is, what its purposes are, what the government can forfeit and the procedure. Let me get to the meat of the matter. How does the government commence a forfeiture action? Whether it's ultimately going to be a criminal forfeiture or a civil forfeiture or an administrative forfeiture by default, the case is going to begin in almost all situations with the seizure of property. Now, to conform with the Fourth Amendment, the government can only seize property based on probable cause. And unless there is an exception to the warrant requirement, there must be a warrant for the seizure of the property. So I say there must be probable cause. Probable cause as to what? Well, what does the government have to prove? It has to prove that a crime occurred, and it has to prove a connection between the property and the crime. So basically, the government can only seize property for forfeiture if it has probable cause to believe both of those things are true. There must be probable cause to believe that the property would be subject to criminal or civil forfeiture because there was a crime and because a crime for which Congress has authorized forfeiture, and there is some connection, statutorily required connection between the property and the crime. It was the proceeds, it was used to facilitate the crime, or whatever. So if the government believes that somebody has committed fraud and that the money in a bank account is the proceeds of that fraud, what does it do? It requests a warrant based on probable cause to believe that the fraud has been committed and that the funds in the account are the proceeds. Now, there are exceptions to the warrant requirement, as in all criminal cases. If a police officer finds $60,000 in cash wrapped in rubber bands in a vehicle and the drug dog alerts to a presence of narcotics on the money, the officer would not need a warrant to seize the property because the automobile exception would apply. But he would still need probable cause. He has to have probable cause to believe that this is derived from a drug offense and this is the proceeds of the drug offense or property that was intended to be used to commit the drug offense. Now, oops. Yeah, that's what I just said, that what a seizure requires. Now, so how does the government then commence the forfeiture action? If it wants to seize the property up front, it does so because it wants to preserve it for forfeiture so that it doesn't disappear while the forfeiture action is pending. That's the government's motive, to preserve the property for forfeiture. So the role of seizure is the preservation of property temporarily pending trial. Seizure is to forfeiture as arrest is to conviction. Seizure preserves the property pending trial, just as an arrest allows the government to hold a criminal defendant in custody pending trial. But there can be no forfeiture. There can be no permanent change in the ownership or the title to the property without a judicial order, or in the case of administrative forfeiture, a default declaration, because no one's filed a claim. So that's the important point. Seizure just preserves the property temporarily. Forfeiture is the ultimate transfer of title to the government. So how do we get to that point? How does the government get from the seizure ultimately to the forfeiture? And it works like this. The federal law enforcement agency, FBI, IRS, DEA, etc., or a state and local agency, sheriff's department from county, whatever, seizes the property based on probable cause and generally with a warrant. If the property is worth less than $500,000, the agency has to commence the forfeiture action within 60 or 90 days, depending on who seized it. And it has to commence that by sending notice to the property owner that says, in effect, hey, we have your property. We're holding it because we believe it's subject to forfeiture, and this is the procedure you must follow if you wish to contest the forfeiture. Ironically, there is no deadline for commencing a forfeiture if the property is worth more than $500,000. That's sort of a artifact in the statute that probably Congress ought to correct one of these days, but that's the way the law works. The important point, however, is that the government cannot forfeit title to the property as a permanent matter without first commencing a forfeiture action by giving notice to the property owner and giving that person an opportunity to contest it according to the procedures that are laid out in the statute and in the rules of procedure. So the notice generally says to the property owner, you've got 35 days in which to file a claim. And if no one files a claim, the property is forfeited by default. If someone does file a claim, then the government has to commence either a civil or a criminal action in federal court by indictment in a criminal case or by complaint in a civil case and it has a fixed period of time in which to do that, generally 90 days. Then the cases go through the normal process, consistent with either criminal or civil rules. In a criminal case, the forfeiture is included in an indictment, and the forfeiture issue is deferred until after the defendant is convicted, if he is convicted, and then it's made part of the sentencing phase of the case. And in a civil case, the parties conduct discovery, they file motions, and if no dispositive motion is granted, the case goes to trial before a jury. If the government prevails, it takes title to the property. That is, if it proves its case that a crime occurred and that the property was derived from that crime by a preponderance of the evidence. If it prevails, it takes title. If it fails, then it must return the property to the person from whom it was seized, and it must pay the claimant's attorney's fees. So that, in a nutshell, is the process.
Well, can I ask a question here, Steph?
Yeah.
Let's say it's money that they seized. Is there any obligation to account for interest or?
Yes, the government is required to deposit the money in an interest-bearing account, and if the government loses and has to return the money, it has to disgorge the interest that it earned, but not what some defendants claim is the interest that it should have earned if the government had only invested in it and more aggressively. It has to pay what it actually earned, not what it might have earned. And the government, by the way, if it seizes cash, always deposits that money, and that's both so that it earns interest and to protect the government's agents from being accused of having stolen the money, so you don't have any cash lying around in evidence lockers unaccounted for. Okay, usually at this point, someone asks, well, I've heard a lot about seizures by local cops, and the whole process seems entirely to be rife with due process challenges. So what's really going on there? So I thought I'd just spend a moment on that. Everything I have just described in terms of the procedure applies whether the seizure originally was done by a federal agent in a federal case or by a state and local police officer or sheriff's deputy. The seizure has to be with probable cause. The notice has to be sent to the property owner within 90 days. If he files a claim, he has a right to a trial by jury, and all of the rest of the due process provisions apply. If he prevails, he's going to get his property back, and he's going to get the government to pay his attorney's fees. What's remarkable, perhaps, about these cases is that the vast majority of these cases where the seizure was originally done by a state or local officer and then turned over to the federal authorities to process is that 80% of them are uncontested. And we could talk, if we have time, we can talk about why that may be. But the important point is if they are contested, all the due process protections apply. It's the fact that the fact of the matter is that the vast majority, no one files a claim. Okay, so let me get on into the remedies and then get us to the case we want to talk about. So if the case begins with a seizure, it has to be based on probable cause. What is the remedy if your property is seized and you think it was seized illegally? You think the property was seized without probable cause, you thought the property was seized without a warrant, or you think that the government did not comply with the requirements for starting a case in a timely way, or whatever you think the government did wrong. If the government has commenced a forfeiture action, then your remedy is to contest that action. So if it's a criminal case and you're the defendant, your remedy is to oppose the prosecution and to contest the forfeiture at the sentencing phase of your trial if you're convicted. If it's a civil case, then your remedy is to file a claim and go through the normal civil process. Now, the exclusionary rule does apply in both criminal and civil cases. You can move to suppress the fruits of an illegal search, but you have to do that in the context of opposing the forfeiture action. An illegal seizure is not a ground for dismissing the action, just as an illegal arrest would not be the ground for dismissing a prosecution. It is a ground for a motion to suppress the fruits of the illegal act, but not grounds for dismissing the case in the first instance. Okay. Now, you can move to dismiss a civil forfeiture complaint on certain grounds. That would have to be that the government had no legal basis, that is to say that there was no statute authorizing forfeiture for whatever the crime that's been alleged, or that the government has missed a filing deadline, or that it did not comply with the pleading requirements in the civil rules. That is, it didn't set forth sufficient facts to create a reasonable belief that there was a basis for the forfeiture here. All of those things could be grounds for a motion to dismiss a forfeiture complaint. A person who's the property owner could also assert that the government's possession of his property is causing him a hardship. He's a farmer who needs his seized tractor to plow his field, and in that case, he would be able to regain temporary possession of the tractor by posting a bond. All of that would mean the property would remain in his possession pending trial. The government, however, could still pursue the forfeiture at the end of the day.
Now, let me interrupt here for a minute, Steph.
Yeah.
The Bennis case, which is the Michigan case, I think that's the name of it, right? It raises a difficult question, but I want you to talk a little bit about how it's tied to the specific state laws, and you've got to be conscious of those differences too.
Okay, so if a state or local officer seizes the property, it can be adopted by a federal agency like the DEA if the seizure was for a federal crime. And so the classic example is a drug offense, because a drug offense is going to be a violation of state law and federal law. And so that's why so many seizures for drug offenses get adopted federally. If it's a seizure for a purely state crime, it cannot be adopted. And the case that you're referring to was Bennis versus Michigan, where it went to the Supreme Court, but it never was a federal case. It was a state forfeiture, and the objection was that there was a violation of the due process rights of the woman whose car had been seized because she's not the one who committed the crime. She argued that she had a constitutional right under the Fifth Amendment to oppose the forfeiture on the ground that she was an innocent owner. The Supreme Court held that she did not. Innocent ownership is not required as a defense under the Fifth Amendment, which is a moot point in federal cases because federal forfeiture law requires a defense of innocent ownership. That's by statute, not by application of constitutional law. So in Mrs. Bennis's case, she lost because she had no right to complain that her husband had used her car for an illegal purpose, but it was a state crime, picking up a prostitute. And in a federal case, if there had been a federal crime and that had gone federally, she would have the right to assert the innocent owner defense because that's by statute included in the law. No.
Thank you.
Okay, so but in general, the point I was making was simply that if the government has already commenced a forfeiture action, your remedy is to oppose the forfeiture action. The only exception, as a practical matter, has to do with if you need the money for your attorney's fees. The Supreme Court held all of this just last year in a case called Culley versus Marshall, which clarified what the law had been, but it had been contested, and the Supreme Court said that's what the law is. So, case has already been commenced. You challenge the case. Case has not yet been commenced. Now you don't have an adequate remedy at law. So as a matter of equity, you have a right to challenge the legality of the seizure by filing a motion. It's Rule 41G of the Federal Criminal Rules, and it allows you to contest any illegal seizure in a situation where you have no other recourse. And so if your property is seized and you think the seizure was illegal and no forfeiture has been commenced that would otherwise afford you a day in court, you file a Rule 41G motion and ask for a hearing. That's the remedy for an illegal seizure prior to the commencement of any forfeiture action. Now, what happened in the Climate United case? Let's go there. Let's see. Yeah, that's what I just said, the remedies and the citation to the rule. And the grounds for a Rule 41G motion can be lack of probable cause, can be failure to obtain a warrant, can be you missed the deadlines, all of these things. Now, what happened in Climate United? The government under the Biden administration put tens of millions of dollars in bank accounts at Citibank for the benefit of the grantees, environmental groups. And the Trump administration, upon taking office, wanted to claw that money back. Now, maybe it wanted to do so just because they didn't like the Biden administration's green energy policy. But their initial approach was to try to freeze or seize the money at Citibank under the forfeiture laws. So, question, is a policy change grounds for a forfeiture? No, there has to be a crime, and there has to be a connection between the property and the crime. That's why we went through all of these procedural requirements. So what did the government do if it wanted to seize or freeze the property under the forfeiture laws in the Climate United case? The acting U.S. attorney in the District of Columbia instructed an AUSA, an assistant U.S. attorney, who was the chief of the office's criminal division, to open a criminal investigation into the allocation of the funds in the Climate United case and to apply for a seizure warrant. So the idea was to allege that there had been a fraud in the way the funds had been dispersed in the first place, and that the money at Citibank was the proceeds of that fraud. And if it was the proceeds of that fraud, then it could be seized or frozen under the forfeiture laws. Now, to seize property under the forfeiture laws, you must have probable cause. Probable cause both that a crime had occurred, that there'd been a fraud, and that the property was the proceeds of that crime. The AUSA, the prosecutor, protested that there was no probable cause with respect to either of those things, and she had declined to apply for the warrant. So the acting U.S. attorney then instructed her to send a letter to Citibank ordering it to freeze the funds without a warrant. Now, the government sends such letters to banks all the time. If there are exigent circumstances, there's no time to get a warrant, for example, the government can ask a bank to freeze a bank account at law enforcement's request. For example, suppose funds are moving through a bank account on its way to a terrorist organization, or to a Chinese bank on its way to North Korea in violation of sanctions and to fund its nuclear weapons program, or some other situation in which there is clearly a reason to seize the money but no time to get a warrant. In such an instance, it is entirely appropriate for the government without a warrant to request a bank to freeze funds, and banks will do that. But it's still a Fourth Amendment seizure, right? And it still requires probable cause. There has to be an exception to the warrant requirement, but even if there is an exception to the warrant requirement, there still must be probable cause. And the warrantless seizure cannot freeze the property forever. It can be seized temporarily, but then the government either has to obtain a warrant or commence a forfeiture action where the property owner has the right to object. Now, in the Climate United case, the AUSA said, you know, if there was no probable cause to get a warrant, then there's no probable cause for a warrantless seizure either. It's the same probable cause either way. And so if I can't find probable cause to apply for a warrant, I can't send a letter to a bank claiming that there's probable cause for a seizure in exigent circumstances. And in response, she was asked to resign, which she did the next day. So the acting U.S. attorney in that case took the application for the warrant himself to a magistrate judge in the District of Columbia, and that judge declined to find probable cause and refused to issue the warrant. The government, then the Deputy Attorney General in this instance, went to another AUSA in another district, which was the Southern District of Florida, and asked that person to apply for a warrant, but that person also refused to do so because there was no probable cause. So finally, what happened was that the EPA sent a letter to Citibank on its own asserting that there was an open criminal investigation. They sent a letter saying, look, in light of this open investigation, we ask you to freeze this money. And as the dissenting judge in the Climate United case ultimately concluded, the EPA had essentially opened the investigation in the hope of uncovering criminal conduct. That is, they justified the warrantless seizure of the bank accounts on the ground that the funds were subject to an ongoing investigation. But a seizure requires probable cause, and the fact that an investigation has been opened in the hope of finding probable cause is not itself probable cause for a seizure. Right? Let me say that again. You cannot justify a seizure on the ground that you're looking to find probable cause. You have to justify the seizure based on the fact that you have found probable cause. So that was the problem. So what did the grantees, what were the grantees' remedies in that case? What could they have done after the Citibank responded to the letter by freezing their money? They could have filed a Rule 41G motion, asserting that the government had invoked the forfeiture laws and seized the property in violation of the Fourth Amendment. That is, without probable cause or without a valid exception to the warrant requirement. They could have done that. The problem was what they could have done and what they did do were two different things. They could have argued that the government, if it's going to invoke the forfeiture laws, has to comply with the forfeiture laws, and it did not do that. But instead, they took a different route. Now, we'll never know what would have happened if the plaintiffs in Climate United had decided to file that Rule 41G motion. There may have been standing issues. The government may have argued that just because the money was in Citibank earmarked for them, that they weren't the owners, and therefore they had no standing to object. Or the issue may have been rendered moot when the government, as it ultimately did, backed off the claim that there had been a crime committed and withdrew that as a basis for seizing the money.
Let's stop for 1 second. I wonder if you'd clarify the standing argument a little bit.
So in order to object to a forfeiture or to object to a seizure, you have to object to something, to the seizure of something that belonged to you. The argument that the government could have made in Climate United was the money was in Citibank earmarked for disbursement to the environmental groups, but it had not yet been dispersed, and that does not convey ownership. They would have responded that we have relied on that it was earmarked for us, that we were drawing on it, that it already had become our property, and that would have been an interesting legal argument. But I can't object to the forfeiture, to the seizure of your property. You can't object to the seizure of my property. You only can object to the seizure of what is yours, and that could have been argued.
Would the reliance interest have worked to create standing, do you think?
That's an interesting question. There are situations where the fact that you would suffer an economic consequence because of the forfeiture, if the property is forfeited, would give rise to standing. I'm a custodian who has custody of your property, and if you're the bad guy, and if the property is taken from me because of your wrongdoing, but I'm liable to you because I was your custodian, I may have standing to object. But that's sort of at the cutting edge of where standing law is on this question.
Okay, thank you.
Sure. So, but what ultimately the government did do was it switched theories, and it argued that all of this was a contract dispute, not a criminal matter, not a basis for forfeiture. And it told the plaintiffs that their remedy was to go to the Court of Federal Claims and argue that it was a breach of contract. The plaintiffs rejected that suggestion. They said, no, we want an injunction under various theories. There was a violation of the Administrative Procedures Act. There was a constitutional violation of the separation of powers, and so forth. But as we now know, while the district court agreed with the plaintiffs and issued an injunction requiring the EPA to release the funds, the DC Circuit, the Court of Appeals, by a vote of 2-1, agreed with the government that this was a dispute sounding in contract, and ended the argument about the misuse of the forfeiture laws. So, what's my conclusion? What all this means going forward, I don't know, because the government may never try to do this again. But if it does try to use the forfeiture laws to go after property held by environmental groups or anybody else as part of a dispute over changing priorities or for whatever reason, because it alleges that the money was somehow connected to a criminal offense, the forfeiture laws and the Fourth Amendment are going to apply, and there are remedies. And those whose property is affected have the right to intervene, either by opposing the forfeiture action after it's brought or by bringing a motion for a hearing on the legality of the seizure. So that's what I have to say. And Professor, if there are more questions, we've reserved another 15 minutes. So we'll be happy to take any questions anybody has.
I think there is a question in the Q&A, and it is: do you think so few forfeitures are contested? One, because criminal defendants are negotiating on global resolution plea agreements, or two, forfeiture targets don't want to make admissions that can be used against them in other proceedings, or in the case in chief, or the targets don't want to claim association with the assets. So,
well, this goes back to why I was saying that the vast majority of seizures are uncontested. The DEA's latest statistics that I saw is something like 80% of the forfeitures of what is alleged to be cash derived from drug trafficking they're uncontested. Number one, I think if the government essentially is sending out a notice that says, fella, on the 1st of May, we seized $60,000 wrapped in rubber bands, 2 kilos of cocaine and a loaded handgun. These are your rights to claim that property. And there are a lot of folks who don't see any merit or advantage to them in doing so. Most of these forfeitures are meritorious, seizures are meritorious, and they're connected to some criminal prosecution. The criminal prosecution may be at the state level, may be federal, or there may be no criminal prosecution, but people don't want necessarily to associate themselves with that. More troubling is that sometimes people don't make a claim because it's expensive to litigate in federal court. And if the government is only seizing something like $8,000 or $12,000, you can imagine what it would cost to hire a lawyer and go into federal court to contest that. Now, you don't have to hire a lawyer. You can do this pro se, but litigating with the government is complicated and it's expensive. And so a strong argument could be made that the government should not be using this tool when we're talking about small amounts of money that could be contested in state court for much less. And then, of course, as you mentioned, there are issues having to do with, waiver of Fifth Amendment rights. The law provides that a civil forfeiture case must be stayed pending a criminal prosecution if the defendant is the party in both actions and he alleges that he'd have to waive his Fifth Amendment rights in the civil case in order to protect his property. And so that he's not forced to do that, he can ask the civil case be stayed. So what happens in those cases is a claim is filed, but there's no litigation over it until the criminal case is disposed of first. And there may be other reasons as well, but I think those are the principal reasons why most of these go uncontested.
I'd like to go back to the Climate United case for a moment. So obviously, if they're going to proceed under the seizure and forfeiture statutes or go down that road, right, they would have had to allege a crime, right, in the first instance. But what was the crime they were alleging?
Well, of course, they didn't ever prove one, and they never had to write it up into a document that they filed. But the suggestion is that they said that there was false statements made in trying to acquire this money, that there was wrongdoing in the manner in which it was allocated. So what they were looking for was some evidence that people had applied for the money based on false pretenses. I mean, the typical situation when there would be a righteous forfeiture action involving the disbursement of government funds is somebody applied for the funds under false pretenses, claiming to be an environmental organization when they were not, claiming that they had contracts to do the things that the law was trying to facilitate, but when they did not have such contracts, claiming that they were a minority business when they had no minority representation, all kinds of things like that. I mean, there are many, many forfeiture cases, criminal and civil, every day that involve the false applications for funds under the payroll protection program during COVID, or involving allocation of money from the government for reimbursement for healthcare expenses and so forth. The number of forfeiture cases in those areas rivals the number of forfeiture cases in drug cases. So what they would have been looking for would have been some misstatement, some misapplication, some false representation regarding eligibility for the money.
So, assuming that that they went through the grant application process properly, and there wasn't anybody, trying to cut corners or doing that, the ancillary claim that the funds were inappropriately disbursed, right, would actually be a claim against the government, not against the grantees, wouldn't it?
Well, that's why it gets back to the standing question. If the money has already been allocated to the grantee and the grantee was responsible for the allocation based on the false representations that the grantee made, then you would apply a but-for test. Would the grantee have this money but for having made the false representation or false application? And if the grantee would not have had this allocation, or there's probable cause to believe they would not have had this allocation, then you can seize the money for forfeiture. And so, a contractor who bids for the contract to build a new bridge, maintaining that he has the wherewithal to do so, that he has the financing, that he has the appropriate minority representation, whatever it is that he's supposed to have, money that's allocated for that purpose would be considered to be the proceeds of the false application under a but-for test.
So, but barring that, then the seizure wouldn't have been appropriate. But the claim, I thought, was also that there wasn't a kind of perfected claim to the money, that it was a lump of a sum that was deposited in Citibank for a variety of grantees under the, I think it was the IRA, right?
I think it was, yeah.
Under the IRA, and that the proceeds that were deposited in Citibank were somehow I don't want to say illegally, but improperly deposited there, and not specifically earmarked to particular particular groups. That is, no group could point to a set of dollars and say those are our dollars.
Right. Well, that would have been the objection made to standing if this had gone beyond the point where it did. If the environmental groups had filed a Rule 41G motion, or if the government had brought a forfeiture action and then they had filed claims, they might well have been tossed out on the ground that the government was correct, that this money was not yet theirs. But what the government ultimately said was, no, you have a contract dispute with the federal government. You claim that you relied on whatever contract theories. I don't know whether it's promissory estoppel or what it might have been, that gave you the right to recover this money in contract. But that belongs in the Court of Federal Claims, doesn't belong here. So have a nice day. And that's where it went.
I wonder if you could talk a little bit about the different challenges that face the plaintiffs in the Court of Claims as against making the APA arguments that they would have been able to assert in district
well, I
court.
wish I could help you with that, but I have no idea how the Court of Claims works. I understand that it's that's where contracts get litigated, and they would have to claim damages based on whatever breach of contract occurred. The violation of the APA argument was basically that there's a certain procedure that applies to revoking an allocation of funds, and that the government did not comply with the Administrative Procedures Act. The other argument was that EPA had violated the separation of powers by taking back money that Congress had already appropriated. Those seemed like two fairly strong arguments, and I'm sure plaintiffs' counsel thought that they were pretty strong arguments, but when the Court of Appeals decided that this was a contract dispute, then neither of those needed to be resolved. They just simply sent it to the Court of Federal Claims.
So this was basically an effort to pull the fat out of the fire, as it were.
Well, I mean, I hope they realized, emphasis on hope, that when a whole bunch of career prosecutors who understand the forfeiture laws to a fairly well tell you that you can't do this, and were willing to resign rather than proceed with something they knew to be wrong, that they would not go down that road again. And that's why they shifted gears. But it's obvious. I mean, I worked in the forfeiture program for a very long time, and everyone who does understands the rules and wants to make sure they comply with them, because the best way to undermine the ability of the government to use forfeiture in the future in cases where it is merited, terrorism cases, fraud cases, drug cases, pornography cases, whatever they are, is to be seen to be abusing the law. Because if there's no public confidence in the fairness of the process, then it'll be lost as a tool in all instances. And everyone who works in forfeiture law understands that, and that's why there was such, in addition to just ethically you don't do something you know to be illegal, but that's why they were very up in arms about the fact that forfeiture law was being abused in this process, because it undermines public confidence in something, in a tool that's essential to law enforcement in a great number of situations.
Has a motion for rehearing been applied for in this case?
I have not checked that. I don't know.
Mm-hmm.
Yeah.
I assume that they would want to have a rehearing en banc.
That would be your options are for a hearing en banc or a cert petition. I'm not sure where they've gone.
Yeah, I'm not exactly sure what the cert petition would say yet. But it's interesting. So, I mean, as this unfolds, not just in this case, but what are do you anticipate that asset forfeiture as a method for clawing back funds is going to be used more as the resistance to the former policies unfold?
Well, I certainly hope not. I think that what happened here, to put it kindly, is that some folks who had no idea how forfeiture law worked had this notion that, hey, if we don't like the way money is being spent, we can just use the forfeiture laws to grab it back. And they haven't heard this very nice little talk for the last hour about how the Fourth Amendment applies. And when they were disabused of that notion by career prosecutors, those prosecutors were forced to resign. But that's not a good look.
Right.
And I'm hoping that they won't do that again. But I talk to former colleagues all the time who are very worried about this.
Right.
Who are called upon to give advice and know that if they say, no, you can't do that, that their career is at risk.
I think thank you very much for this talk. I think the emphasis on, in my view, the important emphasis on procedure and the actual tests that the government is going to have to be put to over the course of this process should be somewhat reassuring. That is, this is not just a slam dunk case where the government, wants to recapture money that it now wishes it hadn't dispersed. It can't be done through absent a crime. Can't be done through the asset forfeiture process as we know it.
That's
At least
right.
that's the way I understand it.
That's a good summary.
Thank you very much. I really appreciate you taking the time, and I look forward to working with you in the future. Asha, I don't know if you had any last words.
No, I just want to reiterate your the thanks that you just communicated, Professor Torres, to our guest, Steph Cassella, for sharing so much on this topic and why it's relevant to environmental organizations and people in the environmental justice space. So this was really great and informative, and we look forward to continuing these conversations in the new year.
Great.
Well,
Thanks
thank
very
you for
much.
having me. And if I can, anything I can do to help out, you just let me know.
Steph, you're going to be sorry you said that.
Thanks
Take
so
care.
much.
Thank you, everyone.
All righty.
Appreciate it.
Bye-bye.
Bye-bye.